I'm an immigration attorney with McKenzie Law Group here in Chicago. Welcome to our naturalization webinar. So the timing of this webinar is important, and I just want to emphasize that. So we have elections coming up in November next year. So I know a lot of you would like to take part, come to the voting sites and actually vote in the presidential elections. And I know that, it's extremely important to many of us to be able to influence the political process. So we decided to host this webinar for those who are interested in becoming naturalized US citizens. There may be a lot of other reasons why you may think that naturalization is right for you. So we will actually go through the benefits of naturalization, through the requirements for naturalization. We will go through every single requirement in particular. And then at the end, I will also answer some of the most common questions that we get when we work on the naturalization cases. All right, so I have a presentation here that I want to share with you. And I'm going to do that right now. All right, give me 1 second. And we will wait for people to join this webinar for just a little bit longer, just for a couple of more minutes to allow people to join this webinar. All right, so I see a couple of more people joined the webinar, so it's the time to start. So this webinar today is about naturalization, the N400 process, and my name is Natalia Blauvelt. I am an immigration attorney with McKenzie Law Group, and here today we're going to talk about the N400 application for naturalization. And just a brief disclaimer here before we begin. This presentation is for general information purposes only. This is not legal advice. Yes, I am an immigration attorney, but I am not necessarily your attorney representing you on your immigration matters. So please contact an attorney or an accredited representative for an individual advice, as your case may need an individual advice. All timelines that we're going to talk about in this presentation are estimates as of the day of this presentation. So you know that the USCIS is the agency that constantly changing the processing timelines. So they are subject to change depending on the government's workload and the specific facts of each particular case. And once again, my name is Natalia Blauvelt. I am myself a naturalized US citizen. So I went through this whole process myself a couple of years ago. And a couple of more attorneys, actually the partners of the law firm that I am an associate of, so McKenzie Law Group, are also naturalized US citizens. So this topic, the naturalization matter, is very close to our hearts. I am also a former international student, and I am a member of AILA Media Committee and a member of the AILA Citizenship Committee. So as a member of the Citizenship Committee, I participate in workshops related to naturalization applications on pro bono basis with the AILA, American Association of Immigration Attorneys in the United States. All right, so the process of becoming a US citizen is called naturalization. It is extremely important to distinguish this process from an application for citizenship and issuing a certificate under Section 322 of the Immigration and Nationality Act. It is also different from the application for a certificate of citizenship, Form N-600. So these two forms are specifically designed for the children of US citizen parents. There are, of course, other requirements that apply. So for example, N-600K is for those who reside outside of the United States, and N-600K may be filed for those children of US citizen parents who reside in the United States. So we do work with both of these applications as well, in addition to the N-400 application. And before we start processing, kind of taking care of the N-400 case, we always screen our potential clients for these specific applications, just making sure that the N-400 application is the right application to file in their specific immigration case. There are instances when people file N-400 applications, and then at the time of the interview with the USCIS, they find out that they are actually citizens and that the right way of doing it was, for example, filing an N-600 application instead of the N-400 application. So just always keep that in mind. And if you are sure that the N-400 application is the right way of doing that, then let's talk about it. So first of all, what are the benefits of becoming a US citizen? You can, like I mentioned previously, vote and be active in the community, influence the political climate in the country. You can travel and reside freely outside of the United States. There is no time limit for you to be outside of the United States. You will not have this requirement to come back to the United States like the permanent residents do, for example. There's a wider range of job opportunities for the citizens of the United States. There are certain jobs that require some additional clearance in order to get the job. So those are usually federal jobs, security clearance jobs. There are some other governmental positions that specifically require that high level of clearance. There are some organizations that deal with the US government, for example, some airline companies, or for example, a company like Boeing may require some additional security check, and there may be a requirement to be a US citizen. As a US citizen, you can also petition for your family members to reside in the United States. So their immediate family members like children under 21, spouses, or parents. So as a US citizen, you can petition for your immediate relatives, or you can petition for the preference category relatives, such as sisters and brothers, sons and daughters, which is different from children because sons and daughters are those children who are over 21. So it's a nice benefit to have your family in the United States. And of course, as a US citizen, you will be able to avoid deportation. Deportation itself sounds very scary. And the US government, depending on the circumstances of a particular case, may make a decision to finalize removal proceedings for a certain foreign national and start the deportation proceedings. So that won't be the case for US citizen. The basic eligibility requirements is to be at least 18 years old, meet physical presence requirement, meet the continuous residency requirement, good moral character requirement, pass the US history and government exam and English language tests, course like reading, writing, and speaking. So these are requirements, and we will go through all of them in this presentation. So before filing for an N400 application for a naturalization, we normally go through certain questions that we think are extremely important for this specific process. So first of all, you need to answer these questions before filing the case. Have you filed taxes every year, your federal, state, local taxes since you became a permanent resident? Do you owe any taxes or child support to minor children? Have you been absent from the US for an extended period of time, for example, 1 year or 6 months, over 6 months? If you're a male, there is a requirement to register for the selective service. So ask yourself, have you registered for the selective service? Have you ever claimed to be a US citizen in writing or orally in front of other people? Are you deportable under Section 237 of the Immigration and Nationality Act? Are you barred from establishing a good moral character permanently or temporarily for the statutory period under Section 101F of the Immigration and Nationality Act? Also, before applying for naturalization, it's always a good advice to file a FOIA request with the USCIS and with the Department of State, just to get copies of all your prior applications, petitions that were filed on your behalf, just to make sure that the information that you are providing to the US government is consistent with what you've been providing to the US government previously. Why it is important? It's important because the application for naturalization is an extremely serious process that requires the officers at the USCIS to do an in-depth review of your immigration files. So this is an opportunity for the USCIS to bring up any issues that were overlooked in the past, for example, to go through your whole immigration file, ask additional questions. This is basically their very last chance to question you on your entire immigration file and immigration history. If there is criminal history in the case, then my recommendation is to talk to an immigration attorney. Criminal issues and criminal history may be complicating the case of naturalization. So there are some potential issues to consider, of course. Like I mentioned, it's criminal history, for example, a DUI or a conviction of a certain crime, trips outside of the US that are lengthy, not filing taxes, not paying taxes, child support, false claims to US citizenship, or voting in the US elections, or failure to register for the selective service. So the very first requirement, let's get to it. It's the residence within the state or the USCIS district. So what it means is that if you choose to apply for naturalization, the requirement is that you live within the state or a specific USCIS district where you plan to apply for citizenship for at least 3 months. So if your plan is to move to a different USCIS district, a different state that does not fall into the same district, then just keep in mind you need to file Form AR-11 with the USCIS, the latest requirement as of this month is that you file this form under your USCIS account. And if you don't have that account, then our recommendation is to create the account. If your plan is to move, but you want to file for naturalization as soon as possible, then maybe you should consider filing an application while you are still meeting this requirement of residing in the area for the last 3 months, for the past 3 months, and then move. So if you do that, then that will be on the USCIS to transfer your immigration file to a new location, to the new office of the USCIS. But you would still need to file Form AR11 to notify the USCIS about your changed address. So just keep in mind that specific requirement. And if you moved to a new place, then make sure that you reside at that place for 3 months. If it's a different USCIS district from the place where you lived previously, then just make sure you apply after residing at the new place for at least 3 months. So the next requirement is continuous residence requirement during the statutory period. So the statutory period is a review period for the USCIS to basically exercise their authority to see if you meet all the requirements. There are 2 statutory periods, 3 years and 5 years. So if you are filing based on being a permanent resident who is married to a US citizen for at least 3 years and being a permanent resident for at least 3 years, then the statutory period will be 3 years. If you're filing based on 5 years of being a permanent resident, so generally people do that, then your statutory period will be 5 years. So during the 3 or 5 years, you will need to meet all the requirements for naturalization. So continuously residing in the United States for the period of either 3 years or 5 years. And as I mentioned previously, a lengthy trip outside of the United States, so it's typically a trip of 6 months or more, or a trip for 1 year or more may disrupt continuous residency. So actually being absent from the United States for 1 year or more will absolutely break the continuous residency. And even the COVID-19 pandemic was not an excuse for that specific break of the continuous residency. There was a USCIS memo issued in that regard, and the USCIS is pretty strict about it. So you may ask yourself, so how do I prove continuous residency? So continuous residency is something that technically you do not need to provide evidence for. So this is something that you just ask yourself, and if the USCIS has any kind of questions related to the continuous residency, they will send you a request for evidence asking for the documents. In my practice, the USCIS has never requested any documents related to the continuous residence except for the tax returns. There's the physical presence requirement. So again, we'll talk about the statutory period. It's either 5 years or 3 years. If a local permanent resident is married to a US citizen for at least 3 years and been living continuously with that spouse for at least 3 years before applying for naturalization, and have been a US permanent resident for 3 years, then a 3-year statutory period applies. So the physical presence requirement basically means that for someone who is applying based on 5 years, the person needs to be physically present in the United States for at least 30 months in a 5-year period. Just keep in mind the physical presence requirement is different from the continuous residency. So continuous residency does not mean your physical presence. So it's basically about keeping your house in the United States, maintaining your lease, having bank accounts in the United States, going to school in the US, filing tax returns in the United States, having your children go to schools in the United States, having an employer in the United States. That all goes to the continuous residency requirement. As opposed to that requirement, physical presence is about literally your physical presence in the United States, on the US soil. So what it means is that you will be checked on this requirement, and you basically will need to prove to the US CIS that you were physically present. You will not need to submit any additional documents to the USCIS to establish your physical presence, because the USCIS will have your full travel history. If they have any questions, then, if your travel history is complicated, for example, let's say you're a flight attendant and you really fly a lot outside of the United States, and that's your job, then in this case, we would recommend doing a FOIA request and filing it with the CBP, with the Customs and Border Protection, just to make sure that you meet the that you meet the physical presence requirement. We also do that for just generally for people who travel a lot. If they are not sure that they met this continuous resident physical presence requirement, then we do a FOIA with CBP. It takes time to receive the results. So if you are not certain about your physical presence in the United States within the statutory period, then our general recommendation is to start the FOIA with the CBP. It will take time. So before you contact an attorney, you may just have this FOIA request going. So that's a physical presence requirement. So it's for a 5-year period, it's at least 30 months. And for a 3-year period, it's at least 18 months. Just keep in mind that the CBP is not stamping passports. As of 2023, they stopped doing that. I-94 forms, the arrival departure record is not available online for the permanent residents. So that complicates situation sometimes, in the analysis of the physical presence. That's why a FOIA may be really beneficial. Another requirement is a good moral character requirement. That applies to the statutory period as well. So if you're applying based on 5 years, you will need to prove your good moral character for 5 years. If you're applying based on 3 years, you need to be a person of good moral character for 3 years. So good moral character itself is not defined by the Immigration and Nationality Act, but there's a large body of case law that tries to define the good moral character. So it's just basically about generally accepted moral conventions of the community, as it was said in a decision of the Attorney General from 2019. And certain criminal matters may preclude finding of good moral character. So here we ask our clients or prospective clients, have you ever been arrested? Have you ever been stopped by the police? Have you ever been given a ticket or seen a judge, put in handcuffs? Or has anyone ever called police on you? So there are certain convictions that would absolutely permanently bar good moral character. So people convicted of these crimes will not be able to naturalize. It's basically aggravated felony conviction or on or after November 29th of 1990, or a murder conviction. There are also convictions that temporarily may bar good moral character during the statutory period, which is either 3 years or 5 years. And those include convictions of, for example, 2 more offenses of any kind for which a person received a total sentence of 5 years, or giving a false testimony in order to obtain immigration benefit, being a habitual drunkard, engaging in polygamy, or being convicted or committing a crime involving moral turpitude. So those are, as an example, I can give you an example of a theft conviction. That's a crime involving moral turpitude. There are certain exceptions related to the crime involving moral turpitude, but we can talk about it later. And those convictions those exceptions, they normally are being analyzed in the deportability matters or inadmissibility matters, not in the N-400 application itself. There are other good moral character, basically requirements that are not necessarily related to the convictions, but if a person willfully failed or refused to support his or her dependents, then that's an issue. If a person had extramarital affair, which tended to destroy an existing marriage, and that's the Immigration and Nationality Act, then there may be issues with the good moral character. Or there's a catch-all provision, which we will talk a little bit more specifically in a minute. So the catch-all provision is basically about any unlawful acts that adversely reflect on the applicant's moral character. So this is not necessarily about convictions. This is just about the commission of unlawful acts. So this catch-all provision may apply to certain unlawful acts that were even committed outside of the statutory period. Those can be minor acts that may concern the US CIS. So in cases like that, we like to submit positive evidence of good moral character. So if there's anything concerning any unlawful acts in the history of a certain person, we always look into evidence of good moral character. So we get affidavits from people saying that you are a good employer or an employee. We get letters from church, from police officers, from neighbors, friends, relatives, a school where children of an applicant go to, for example. So there's definitely some amount of creativity that we exercise in getting, this positive evidence of good moral character. Every case is different, and if you think this is a concern in your specific case, I would definitely talk to an immigration attorney. We also had in the past dealt with cases of failing to support dependents. So this is something that an applicant may try to fix by basically paying that child support or proving to the USCIS that the person actually has been paying the child support and the USCIS has the wrong data. This is something to think about. It also requires some creativity on how to respond to the USCIS's allegations. There is also a requirement of a civics test. So this is the test where the USCIS will be testing you on the knowledge of the US government structure and the US history. As of now, and that's good news, we're using the 2008 version of the test, which has 100 questions. And just a note here, when we had a different president who came into the office in 2016, the version of the civics test changed and it became 200 questions with a completely different requirement to pass the test. So it became more complex. As of now, it's 100 questions. They are basically not all of the questions have to be answered to pass the test. The way the USCIS tests is that an officer asks questions, 10 questions. So if 6 out of 10 are answered correctly, then the USCIS officer may decide that you passed the test. If you answer 6 questions correctly, continuously, then the test will stop at the question number 6. There is also basic speaking, writing, and reading requirement in English. So the USCIS is testing your speaking abilities by just talking to you. So being conversational with the USCIS officer helps. Of course, not too much, but just being friendly, answering questions right away. that will basically testify to your speaking ability. English writing and reading tests will be conducted on an iPad at the USCIS office. You will be given 3 attempts. If, for example, you fail the first time or the second time, there will be a 3rd attempt to do right on the test. There are some exceptions to this requirement based on the age and the length of time that you've had your green card. The application itself has those listed on the application. So if you've been a resident of the US for 15, 20 years and you're over 50 or over 60, then bring it up to your immigration attorney, or as immigration attorneys ourselves, we will always determine if you are exempt from the English language test. There are also medical conditions that may allow for an exception from both civics test and the English language test. So those exceptions have to be certified by a medical professional, a certain medical professional, and Form N648 has to be issued and brought to the interview with the USCIS. So basically, the process for requesting this medical certification for disability exceptions is calling the medical office and requesting an exception to the English and civics testing because of physical or developmental disability or mental impairment. This is up to the doctor to decide if the doctor will certify the form, and then when the form is certified, a USCIS officer will eventually make a decision on the form itself. An officer may decide that the description of certain medical issues is too vague and that it's not specific and may deny an exception, or an officer may accept that form and exercise this exception. So much about the civics test and the English test. So the understanding and attachment to the principles of the US Constitution are important. So you will have to take the oath of allegiance to the United States, and the application itself actually has certain questions such as, do you support the Constitution of the United States? Are you willing to bear arms on behalf of the United States if the law requires? So you can see those questions on the left side. And then on the right side, you can see the oath of allegiance. So this is something that you will do post approval of the N400 application during the ceremony. One question we get from some of our clients or prospective clients is, how important is it to answer yes to the question if you're willing to bear arms on behalf of the United States if the law requires? So I will give you an example of when an applicant may be able to actually answer no to this question. So for example, if an applicant holds certain religious beliefs related to bearing arms in general, then we can let the USCIS know that this goes against the moral principles of the person, or this is something that goes against the religious beliefs. And there were instances when the USCIS officers completely understood and the application was adjudicated in a positive way. I also wanted to touch base on certain questions we receive from our clients. So a lot of people we work with, we actually have some, prior applications filed or Form I-751 petition for removal of conditions filed before we start talking about the naturalization process. A lot of our clients start working with us, our naturalization clients have started working with us years ago, first doing let's say, a business visa, then switching to a marriage-based green card, filing an I-751 petition, and then at some point filing for a naturalization. So it so happens that some of our clients or prospective clients have a pending Form I-751 petition to remove conditions on a green card that was obtained based on a marriage to a U.S. citizen or lawful permanent resident. And then, you just need to understand if when you have this pending I-751, you may be able to file an application for naturalization. The I-751s take a very significant amount of time to be adjudicated. There are some extensive delays within the USCIS specifically related to the forms I-751. Some of them are pending for 2 years, and this is just something that we think can be, in certain circumstances, fixed if a person files for naturalization. So let's talk about this question. My spouse and I timely filed our Form I-751 petition to remove conditions on residence with the USCIS. I had my green card and been married to a US citizen for at least 3 years. Can I apply for naturalization while my I-751 is still pending? So generally, you should be able to apply for naturalization if you meet the other requirements. The USCIS will consider both the petition and the application at the same time. This petition and the application may be included in the interview process, just simultaneously. So the USCIS may be questioning on the petition and on the N-400 application at the same time if both forms are still pending. The USCIS may ask your spouse to come to the interview if you have an I-751 pending with the USCIS, and our general advice is to have your spouse somewhere close, within a walkable distance to the USCIS, or just come to the interview with you. Sometimes the USCIS would not allow a spouse to come, to walk inside the building, but being somewhere close, just in case if an officer decides that your spouse's presence is needed, that's generally an advice that we give to our clients. Another question that we also get, so in a case where a person is no longer married and to a US citizen spouse, for example, and filed Form I-751 petition by herself or himself, and then had a green card for at least 5 years, can this person apply for naturalization? The answer is yes, but based on 5 years. 5 years, not 3 years. So the USCIS again will consider both applications at the same time, and it will need to approve the I-751 petition before granting the application for naturalization. Another question related to the I-751, and that's the last question that I will discuss here. So if I file my citizenship application while my I-751 petition is pending, will my I-751 petition be approved faster? So no guarantees here, as always. Working with the USCIS just sometimes is unpredictable, but while we cannot guarantee the results, we can tell you that sometimes it speeds up the I-751's adjudication. So filing for naturalization while the I-751 is pending sometimes, speeds up the process. So when we determine that a person is eligible to apply for naturalization and has the I-751 pending, then we reach out to that person and let them know that there is an option to apply for naturalization. So we do a general screening for that kind of application. If we determine that everything is fine, a person can file, then generally it would be my advice to file. N-400 applications are normally pending with the USCIS for about 12 months before the interview, while the I-751 petitions may be pending for 15 or 25 months. So it just makes sense in certain circumstances to file an N-400 application. What is important here is that, letting you know that certain offices, USCIS offices, for example, the one located in Chicago, in New York, in California, they've been adjudicating cases faster in 2023. I've been practicing for several years, and I have never seen a case being adjudicated within 4 months until most recently. I had an N-400 case adjudicated in Chicago within 4 months. This is absolutely a record processing time. And that's another reason why we have this webinar hosted today in December. We just think that this is a trend that we've been seeing at the USCIS at the certain offices. No guarantees that your particular application will be processed within such a short period of time. But if it's a pretty straightforward application, if it's well documented, then you may as well, participate in this fast processing. It may or may not happen, but just keep in mind that this may be an option. So let's talk about the whole process. Here is a flow chart that we created at McKinsey. So we start the whole case with gathering documents. So we send you questionnaires, list of documents needed for the case. And if you're doing this case yourself, per se, then start with gathering documents. Complete Form N-400, the application itself. Send form to the USCIS with the supporting documents. Make sure you use the current edition of the form and that you file the form with the correct office. So you look at the filing addresses and make sure that the filing address you're using is the correct address. Once the USCIS receives the application, it will review the application and documents and will issue a receipt notice. A receipt notice is something that the USCIS sends in the mail or online under the foreign nationals account online. So the receipt notice basically would mean that the case was accepted by the USCIS, the amount of the filing fee is correct, and the filing address was correct. So the case will be in the processing. So that's generally good news. A notice for the biometrics appointment will come a little bit later. So normally it comes within a month of the acceptance of the application by the USCIS. A person goes and submits biometrics, so fingerprints, and the USCIS contractors will take a photograph of the person, and then the waiting begins. So we would wait for the USCIS to adjudicate the application and get ready for the interview. The interview is absolutely necessary in this kind of a case. There's no option to skip the interview. It will absolutely be scheduled. If you cannot make it to this interview, then there's an option to reschedule. It has to be done in a timely manner. If it's done untimely, the USCIS may decide that a person failed to attend the interview and may deny the whole case just because they think that a person failed to show up. So if you have the interview for naturalization scheduled, our advice is to make sure to attend the interview. We understand that sometimes it's not an option, and sometimes we file requests with the USCIS to reschedule the interview. And as a bureaucratic machine, the USCIS sometimes does not process those requests in a timely manner. So there are no guarantees that they actually will process a request for rescheduling. But even if they don't, and even if the USCIS eventually issues a decision, denying the case for the failure to attend the interview, there may be an option to argue with the USCIS that such a decision was issued incorrectly. So if everything goes well, after the interview, you will receive a notice of the oath ceremony and hopefully become a new citizen. You will be issued a certificate of naturalization, give up your green card at the ceremony facility, and basically become a US citizen. So that's a moment where you should consider applying for a US passport, because to travel internationally, you will need to use that passport. If you have some travel plans pre-scheduled, you can request to reschedule the oath ceremony just to be able to complete your travel plans before you become a US citizen and have this requirement to use a US passport. All right, so if everything goes well, it's always great. But sometimes things don't work out as well. Sometimes there are red flags on the application. There are certain criminal convictions that complicate the case. There are some changes in immigration history of a person. And in that case, the USCIS may determine that it needs more evidence. So it would issue an RFE request or a notice of continuance. In that document, the USCIS will outline what it needs from the applicant to continue the process. Our recommendation is to always respond to the request within the response period indicated on the notice. Allow some time for the mail service to deliver the response. Make sure you send your response to the correct address. The address will be indicated on the notice. Make sure that you respond to every single request outlined in the notice of continuance or an RFE request, even if it seems unreasonable, repetitive, or just strange to you. Then just make sure you respond to every request, even if it's about something that you previously provided. If you think you've provided those documents, go double check the documents, review them again. Maybe there is a page missing. Maybe there was some scanning issue with the documents, and always make sure to respond. And obviously consult with an immigration attorney if you need assistance. Consult as soon as possible, because the review of this RFE will take time, and then the response will take time, and there is a certain period for this response indicated on the notice that you need to comply with. All right, so let's see what's next. So one last slide I have here is about the delays at the USCIS. So if you've been a foreign national in the living in the United States for some time, you're probably already aware about the delays at the USCIS. This is not news to someone who has been dealing with the USCIS for an extended period of time. So generally, the N400 applications have to be adjudicated by the USCIS after the interview within 120 days. What happens in reality is that the USCIS sometimes takes more than 120 days to review the applications. There is an option to file for a judicial review of the application. So that is done in the federal court. It's a completely different immigration matter that is normally not included in the N400 representation agreement. So if you are considering filing for a judicial review, you may do so with an immigration attorney who has prepared your case, or you may hire somebody else to do that. If the USCIS is not scheduling your N400 interview for quite some time, then you may think about an option to file a lawsuit with the federal court. It's called mandamus, and try to speed up the process. A mandamus lawsuit, in my experience, can really push the USCIS to do the job. Here at McKinsey, we also assist with this kind of lawsuits. You may also, if you're not willing to deal with the federal courts, engage in litigation, bear the costs of litigation, you may also communicate with the USCIS by writing to them. It's not always effective. It may not result in any action or any result, but this is something that generally may push the application, internally. So as attorneys, we keep in touch with the USCIS by submitting, some online requests. We sometimes would send a letter to the USCIS. And even though we know that, those online requests are often being denied by the USCIS, or we never receive a response to our communication we sent to the USCIS. But what I noticed is that when we submit those requests, when we communicate even only on our side with the USCIS, things happen, things start to move, and applications sometimes would get approved. If the delay is extremely, extremely long, so if it takes several years, then we may contact the committee at AILA and just, figure out how we can communicate with supervisors at the USCIS. All right, so this was an N400 webinar. So I hope you found it to be useful. We're just a phone call away. And thank you all so much for joining this webinar.